CERTA staff and its Workers' Compensation Carrier Summit. I'd like to speak for 11 minutes, reserving 4, and I'll begin this way. This case has been thoroughly briefed, and I believe I've articulated everything I needed to in those briefs, so I would like to stress, if I may, the important policy considerations that are attendant to the Court's decision today. And those are relating to one hand the EMA and its role, and on the other hand the major contributing cause standard. In taking the first, the EMA, I think there is a danger in the accumulated cases of inverting dramatically the purpose of the EMA. Now, I understand in McKesson and all the Court's cases it views it as a CSE question, and I've suggested there's a partially de novo element to it. And here's the distinction, I think. The process of scrutiny remains the same in a CSE, but the thing we are scrutinizing is a difference with a distinction. It is informed by an important public policy expressly articulated in the statute that the EMA is to be the decider of the medical disputes and thereby eliminate litigation. Send the parties home. This thing is over. It's been decided. As I said, it's not a perfect means of resolution, but it's a good enough means. Now, what happens is that in the conventional application, it's a little bit reminiscent of the employer carriers that were too overzealous in putting down fraud in every case for a few years, and they almost threatened that golden goose. And then they pulled back based on the Court's guidance that there would be consequences for an improvident entry on the pretrial stip. So what we have now, instead of the purpose of the EMA being a kind of first inning sudden death overtime, it has become appended to the end of every case as a protracted, dreaded, costly, time-consuming extra innings. The purpose of the EMA is to eliminate litigation. And you can only have that purpose function if the EMA is held in a venerated position in the statutory framework as it is intended.
Well, let me ask you a question. So, of course, the JCC, if he or she is able to articulate clear and convincing evidence, might be able to reject the opinion of an EMA. And I know it's your position that wasn't done in this case, but how would that have been done in this particular case? In this particular case, the EMA spoke with certainty, but the fact he could not speak with absolute certainty to eliminate the claimant's history is what gave the JCC and the claimant the rhetorical wiggle room. And they applied issues of rhetoric rather than the substance. It was a decision notwithstanding the verdict, because the EMA adopted essentially in substance the same position as the employer carrier's initial physician, Dr. Peterson, and that was that this thing is completely pre-existing. No material aggravation has occurred of any kind. And in the one hand, claimant's own words had become sufficient to trump the EMA, because he had strewn behind him a lot of history in this case, in the record, and he has decided on seeing. Now, what I'm talking about here is marked impairment, restrictions, accommodations made for him by the employer, self-medicating pain which he described afflicted him from sunup till sundown, and the employer accommodated his schedule. Now, all of that gets swept away by rhetoric. The claimant says, oh, I said those things, I'd like to sweep those under the rug. There are two implements needed to sweep that under the rug. The attorney, who carefully supplied the broom and moved the words around, but they're missing the rug. The words are swept around, but you walk over, they're still there. All those words are still there. The judge says, never mind that. Claimant said he had no medical treatment. So that's what we're going to say trumps the actual history of actual restrictions, actual work accommodations, actual pain, actual self-medication.
No, but you said there was no material aggravation. Well, there was a workplace injury here that aggravated a pre-existing condition.
I'll go with the first phrase, Your Honor. Well, yes, I mean, there was a superficial transitory something, but the point is the EMA tells us, per the 440-09 per N1, you need objective medical evidence to support anything further than the little red marks and the shortness of breath, which he described when he fell from the lift of his pickup. And why was he using a ladder to get to the bed of his pickup truck? he described all the limitations and difficulty that he had. He didn't put that two together. He said it's just more convenient for him. This fall occurred because he needs a ladder to get from the floor from the ground to hit the bed of his pickup truck. That ladder fell. He said he was out of breath for 40 seconds, and he had some red marks. And don't forget, I have a whole baseball metaphor here. He had to come back the next day and remind the physician that his shoulder, which had been horrendously massive pre-existing conditions, quote from the Dr. Peterson, 3 prior surgeries, each one brought on by pain. All 3 prior shoulder surgeries, right and left, were brought about by pain. So when this wasn't even noted on the first day. On the second day, he says, you know what? Immediately, my shoulder was no longer mobile. I couldn't use it anymore. You doctors didn't write that down. Well, that's by the boards now. We accepted something happened. So then, is there any permanent residual aggravation, a change, an alteration in the physical and anatomical pathology? And that's where the statute says, look to the medicals by objective criterion, not the raw ipsa dixit of the self-interested claimant. And in this case, in contravention of the statute, you have a 180-degree opposite of his history where we're supposed to ignore that he said those words. In this instance, to respond to your question, the only evidence that there is of an objective pathological change is his raw ipsa dixit. So we go from ignoring the history to venerating his say-so over and above that of the EMA. If you study the EMA's opinion, there was no ambiguity about it, except, as I outlined at length in the brief, especially the reply, the virus that he had imported into the EMA's opinion by asking the EMA over and over, can you eliminate the fact that he says it was different? And the EMA used polite, decorous language to suggest repeatedly, apparently, it was different because he says so. But there are no objective markers of that. End of story under the statute. Next level, EMA said so. Double end of story under the statute.
Well, let me ask you, if we agree with you, wouldn't the proper remedy in this case be a remand to the JCC to consider the claimant's alternative theory of recovery, since that was not, the JCC had no need to issue any findings of facts or conclusions in that regard?
Well, which alternative theory? You're talking about major contributing cause? Pardon?
The hindrance to recovery, the
Oh,
second.
that was
the
not-
tipsy coachman argument that was made.
It was just an argument. I don't believe it was developed in any of the in the EMA's opinion. And the EMA dealt with a dispute in the medical opinions of the physicians, and the EMA resolved the case. Now, there is that alternative, and I suppose Your Honor could remand it if that is your inclination, to see whether there was a hindrance to recovery. But you've got to understand the irony here is—
But you'd agree that there weren't findings along that line.
Well, Dr. Fiore even says that the surgery would be necessary for the underlying condition. The surgery that has been awarded was necessary for the underlying condition. It wasn't necessary to treat the underlying condition. He actually, I believe, suggested therapy as a precursor to that decision. And not only that, but he said this is a 50-50 case, which is, there's a little ironic or an inconsistency or deliberate or inadvertent in the statute. Under the 44009 major contributing cause standard, you need more than 50%. So claimant's IME did not satisfy the statute. Paradoxically, under 440.093, the mental and emotional injury statute, the statute does say at least 50%. So his IME would have satisfied the 093 psychiatric injury statute because there the legislature, for some reason, put at least 50%. But under the traditional major contributing cause statute, it requires more than. And we put in our briefs, blocked and indented, Dr. Fiore said it's 50-50. So he didn't even cross the threshold by that meaningful 1% margin. But the surgery is the EMA said, Dr. Peterson said, this massive pre-existing condition is the basis for the need for this surgery. And so amelioration doesn't really get us very far.
The JCC seemed to get to its result by using by putting a lot of weight on the fact that the pre-existing condition her finding was independently require the treatment. Is that?
There is that language, but that's not supported by competent substantial evidence in my view. I think that there is the evidence pointed virtually conclusively, if we adopt the EMA's finding, to the fact that the pre-existing condition is what caused it. I think if you look carefully at the judge's order, the judge was most persuaded by the fact there was no medical treatment since 2008, and that was the judge's way, incorrectly in our view, of dismissing the significance of this floridly symptomatic individual, getting accommodations by his employer, getting work schedule changes, self-medicating himself, describing his own pain as occurring from dawn till dusk. This is the claimant who had 3 prior surgeries spontaneously generated by pain, and now from a fall from a lift gate height where he was out of breath for 40 seconds and had some red marks on his elbow, we are asked to, and then says a day later, you guys forgot to note that my elbow was basically immobilized by this accident. If there was a clear case for contrivance, as subscribed to by the EMA basically, this is that case. All that has detracted from that is rhetoric and not substance in the record.
Well, let me go back to just a procedural question, and we talked about the issue of whether a remand would be appropriate to develop the alternative theory. And from just a pure procedural perspective, do you think that's appropriate given that that wasn't developed below, it wasn't raised in a motion for rehearing, or is an outright reversal necessary if we agree with you?
In my view, the reversal is necessary because it doesn't seem to be a worthwhile task to sort out from the opinions of the EMA and the physicians, including Dr. Fiore's 50-50 and the the employer's physician, that there was a hindrance to. But if this
would that require findings of fact, though, on our part?
Well, yes, Your Honor, we'll have the complete autonomy over what to find.
Well, right. So we couldn't make the findings of fact, and of course,
I don't think that's inappropriate. I think you have to see whether or not there is, whether it is a debatable point or whether the evidence would not. There is no competent substantial evidence of the hindrance theory, which is my position. And just to close very briefly, Your Honor, major contributing cause, the other policy concern, I believe it is clear to our view of the judge's actions that the judge has conflated catalyst with cause, which is a complete upending of the major contributing cause statute. The pickaxe example I used in the mine sparking hours or days or weeks of coal dust accumulation. The pickaxe was not the major contributing cause. Of course, the mine was functioning perfectly well till that moment, and that's the ruse that is always used. Perfectly well till that happened. But that conflates catalyst with cause, and the legislature has set down the bedrock principle that under the Florida Workers' Compensation Act, we look at the major among competing, if there are any, causes. And the ruse that the working was fine before the accident is a way of trumping that legislative intent and installing catalyst versus cause, upending, as I say, the entire purpose. So we request, Your Honor, that the court reverse the order of the judge of compensation claims and dismiss this claim for a shoulder surgical procedure. That's what was awarded, and that must be reversed. Thank you, Your Honor.
Good morning. I'm Wendy LaQuasto of Fox & LaQuasto. I'm here today representing appellee Kenneth Owen, who was the claimant in the proceeding below. I guess I have a very different view of this case than appellant. Number one, I think that we really differ on the extent of the pre-existing condition. Yeah, we're not disputing Mr. Owen has a pre-existing condition in his right shoulder, but he hadn't received treatment from that for 13 years since he had the surgical repair of that shoulder. And if he was as hurting, disabled as the employer carrier would have this court believe, I think it would have been impossible for him to be a contractor running his own business before he became a gas technician.
But isn't that where the EMA comes in? If the EMA says that the pre-existing condition is the major contributing cause, How much weight are we supposed to give to that under the statute?
Well, and the JCC, it's the JCC's job to resolve all the evidence, and as Judge Ray pointed out, this is not, as the EC would like, you get an EMA and that's the end of the case. The JCC does actually get to look at that testimony, and if there's clear and convincing evidence, can reject it, and the JCC gets to interpret that testimony, which is what I'm maintaining in this case. The JCC interpreted the totality of EMA Green's testimony as standing for the proposition that the aggravation caused by the work accident, which caused decreased range of motion, decreased strength, which are objective findings, that aggravation is what's necessitating the surgery. He didn't need the surgery before the accident, now he needs it. And he needs it to address the decreased functionality, the decreased range of motion, the decreased strength, which were subject to medical testing and our objective findings. Dr. Green said that.
Does your position conflate a major contributing cause with a major contributing catalyst?
No, I don't believe so. You know, and that's where I say that it's important to understand that we really see that this is different. You know, the EC would have Mr. Owens as barely being able to function because he was in such a bad state before this, and yet here he was lifting pipes overhead, crawling in attics, crawling all over, doing heavy labor before the accident, and after the accident, immediately he could not lift his arm. And to this day, he can't lift his arm overhead. This is a substantial change in functioning. So this isn't the straw that broke the camel's back. This is a serious accident. I mean, you know, the man fell from a vertical position 3 feet off the tailgate onto a ladder and jammed his elbow into asphalt, which pushed up into his shoulder. It's not a few red marks or an abrasion.
And I think, right, and I mean, that's probably why logic and common sense directed the JCC to the conclusion that was reached. Where I'm struggling is the EMA's testimony, record page 99, is pretty emphatic that the underlying arthritis, that was the major contributing cause. It was asked over and over, and he emphatically said yes, yes, yes. So how did the JCC articulate the clear and convincing evidence to reject the EMA's decision?
Well, our position in the briefs are that she didn't reject. She just interpreted the entirety of the testimony. But I understand where you want to go with this, and your question earlier was, how could she have done that? Well, if you look at Dr. Green's testimony, he focuses solely on pathology, the underlying pathology. He basically, although he says there's increased symptoms, when he's talking about MCC, he's ignoring the symptoms. He's ignoring the decreased range of motion, the decreased strength, the reasons that the surgery are needed to restore the range of motion. He's ignoring that in his MCC analysis. And so his testimony really doesn't satisfy the definition of MCC when you're looking in those statements about what MCC is. When you look at the totality, he's saying, well, yeah, there's decreased range of motion, there's decreased functionality, and that is a change of condition. And yes, that is caused by the accident. And so when he says all those things about the functionality and the range of motion and the symptoms, and he says that's what the surgery will treat, then that's what he's saying. The reason we need the surgery is to restore the functionality, restore the range of motion that was lost as a result of this accident.
Well, he's saying as a result of the pre-existing condition that it was a high probability, it was chronic, it was severe, and there's a high probability this is happening anyway. Yes, we had this catalyst that maybe speeded it up, but it was going to happen.
I wish that Dr. Green would have said different things. I'm not saying I don't have a hard, that it's not, that his testimony could be construed as the EC would want it. But that's not what the JCC did here. And the JCC is the ultimate finder of fact, and the JCC gets to interpret the medical evidence, and MCC is a fact finding.
Let me ask you, what is the CSC for the JCC's statement, essentially that he was asymptomatic prior to the accident? Because I read the record a little bit differently than that.
Well, I guess, in terms of when you're looking at how the EC would have it done, like he was taking medicine every day and being accommodated every day, the claimant testified that on occasion when he had a heavy lifting, a lot of heavy 20-pound, 22-inch pipe that was 20 feet long that weighed 100 pounds, when he worked with that kind of stuff, he had a sore shoulder and he had to take Advil or ibuprofen for it. So he said that. But but he said it was on occasion, and he said that he was accommodated on occasion. On occasion is not that I'm treated every day, or that I'm suffering from symptoms every day. You have to remember what this man did, and there's no testimony that he didn't do his job. The only testimony in the record is that he did his job. So if you want to say, well, maybe he wasn't completely asymptomatic because he took Advil on occasion, well, okay, then maybe that's not quite true. But in comparison to Advil on occasion, to having to go to a doctor and have inflammatories, pain medicine, physical therapy, or something like that, I think taking Advil, we all get aches and pains. Does that make us symptomatic as to our back condition? We push the sofa, we have to take Advil. Does that make us symptomatic, every day? No. That makes us, one day we did something and it bothered us and we took Advil. And that's what the case is here. There's no information. And I think it's important to understand that, in between 2000, when he had the right arm surgery and the accident, he had two surgeries twice on his left shoulder because of problems. And there's no mention in any of those medical records about, hey, my right shoulder's bothering me too. Could you give me some therapy for that? Or could you give me some medication for that? And it's the same doctor, so it seems kind of to make sense that the absence of any evidence in this case about treatment does make him asymptomatic.
So we also have the EMA's statement, opinion, that there is a high probability that he would have needed this surgery even, notwithstanding the accident, and that's coupled with the, this asymptomatic, or it seems to me that the JCC has kind of rejected that in determining that he was asymptomatic prior to the accident. So what are we to do with the JCC's opinion in that regard, that there is a high probability that the surgery would have been required anyway?
He was cross-examined on that. 1 week, 2 weeks, a couple days, a couple years, I don't know. And, the man worked for 13 years after his surgery, and he never needed anything until he had this traumatic fall. So, that he would have needed it eventually. And I want to take you back and really encourage you to read Dr. Green's testimony about the functionality. That he says that's a change in condition. He's real clear, he's not as clear as he wants to, as I'd like him to be, but, he said, when he asked, well, isn't that a change in condition when he can only raise his arm this much now, right after the accident? Isn't that a change in condition? Well, apparently, he said, apparently. And what's the surgery going to treat? The loss of range of motion, the loss of strength. That's what it's going to treat. So, that he eventually might have needed it on his own, that's speculation. That's not CSE. And, speculation is not CSE to say that. So, although Dr. Green did say eventually he would need it, that was his opinion, he also testified, and I bring you back to it, and that's what this JCC did, looked at the entirety of his testimony, look at his range of motion. Before he could do his overhead work, now immediately after he can only lift his arm this far. Under the EC's interpretation of this, you're dealing with a situation in which a person who is able to do a job for many years that involved heavy labor could fall, have a traumatic fall, immediately be unable to lift his arm over his head, and now he would get no benefits at all. And I don't think that was the purpose of the workers' compensation statute.
So let me ask you about go back to the alternative theory that you raised in the brief and that we discussed a little bit with appellate's counsel. They suggested that if we decided that was an adequate means of recovery, that there's really no reason to remand for that, because there's no evidence in the record that would have supported it anyway. Do you agree with that?
I disagree.
Tell me.
On page 13 of my brief, I summarize Dr. Fiore's testimony, and I say, he says, testified that the pre-existing osteoarthritis interferes with treating the rotator cuff tear because it will prevent rehabilitation of the shoulder, and Owen will end up with a stiff shoulder and less function, which is why arthroplasty was invented. The chance of success of rotator cuff repair alone with osteoporosis is poor. So there is evidence, and there was argument made in the closing argument by claimant's counsel that said that this could also be granted under a hindrance theory. So it was developed. Maybe it's not the best thing in the world, the most developed argument, but there is evidence from Dr. Fiore, so you wouldn't have to make a factual finding. No one else addresses this. Fiore does. There's evidence in the record, and there's argument. It is developed. I know I only have 3 minutes left, and so there was a couple things, when you listen to opposing argument counsel, you always want to, jump up and say stuff, but you can't. You can't. So I just want to check off a few things that I did write down. He started out with a public policy argument. This court doesn't decide cases on public policy. It decides cases on CSE, and MCC is a CSE question. I repeat that Dr. Green's analysis on MCC lacks any consideration of the symptoms, which is what necessitates the surgery. The EC repeatedly says there's no medical evidence. Dr. Green testified that the range of motion and strength tests done during physical examination are objective findings. The EC talks about how the accident happened because Mr. Owen apparently stupidly climbed on this ladder. Well, the workers' compensation system is a no-fault system, so that's irrelevant. Into the 50-50 discussion
that was what.
I'm sorry?
Yeah, I'm sorry. I don't get the impression that's what counsel meant about getting on the ladder. I thought it was just evidence that he was impaired enough that he needed a ladder to get onto a pickup truck from the ground.
I think it was as he described it, Mr. Owen described it, he used the ladder to crawl into the back of the truck. He had to get into the back of the bed, so he put the ladder up there, and then he also used the ladder to climb over the things that were in the back. So it's not, but in any event, I just mentioned that my point is that it's a no-fault statute. So we don't blame a claimant for how he was injured. On Dr. Fiore's 50-50, that's apportionment testimony, which is under a different statute and has different criteria, requires permanent impairment. It's not an MCC analysis. And then that brings me back to Dr. Fiore as being under the hindrance. So those are the points that I wrote down. If you have any other questions, I'm happy to answer them. If not, then I would just say that we ask that you affirm the order in the totality. There's been some discussion of remand here. I think that if there is some sort of remand, although that's not what we want, that you need to remand for more than just Fiore. If you were going to do that, or the hindrance theory for findings on that, you would need to remand for the JCC to give her the ability to make findings about rejecting the EMA if that's what you conclude she did, which is what the EC is saying here. You would have to give her an opportunity to do that, and then you would have to also give her an opportunity to flesh out the hindrance findings if you needed that. But we submit that that is not required because there's CSE to support the MCC finding, and there's no misapplication of the law as to MCC, and the order should be affirmed in its totality. Thank you.
Thank you.
To Your Honor's question, how did the JCC articulate the overcoming the statutory presumption? She didn't. She didn't cite the statute. She didn't cite the presumption. Our policy argument was that the statute is in danger of jeopardizing, that we are in danger of jeopardizing the public policy, informed by the strong dictates surrounding the EMA statute with its one safeguard in case the claimant can override that strong presumption. And by the fact that the judge has not cited that presumption, has not even referenced it in the order, in the judicial order, is evidence of our feeling that this has become a just same old, Your Honor, just another overriding an EMA presumption, which is making cases cost more money and last longer. That's exactly the opposite of what the legislature hoped to avoid by truncating litigation with the EMA. And this business about his arm is this way now and that way, it's his raw ipsa dixit. And the EMA kept being asked to accept it. If he says that, is it a change? Well, apparently, that would be a change. Apparently was if I'm forced to accept that. Now remember, this fellow's boss is his dad, boss is his son, in terms of the accommodations. And we didn't say he wasn't, he was getting by before. I didn't say he was an invalid before. He was getting by. He strongly showed how he accommodated these restrictions. And the fact is he's still getting by. He just says now that he's worse. And the 440.091 says you need something more than raw ipsa dixit. Medical evidence, objectively established. And that's what's missing. And so that is why we centered on the policy argument first. All of these policies are in danger of being frustrated by a too cavalier deference to the JCC's CSE, which is why I started out by saying the process may be the same, but the thing looked at is very different. And so when you have a judge who doesn't even reference the standard, I think we have cause for concern. And this case is emblematic of that. Thank you very much.
Thank you. Thank you to both counsel. Very well argued. We'll give